Hi, everybody. Dave here. Our CyberWire podcast team is taking a well-earned break for the holidays, but don't fret. We'll be back January 2nd with all new episodes of our show. In the meantime, we're running extended versions of some of our favorite interviews from 2019. Merry Christmas and Happy Holidays to all of you. Stay with us. My guest today is Daniel Garrie. He's co-founder of Law and Forensics, a global legal engineering firm, and editor-in-chief of the Journal of Law and Cyber Warfare. If you've ever been sued or have the occasion to sue someone, you know that part of the legal process is discovery. These days, much of that process is eDiscovery, dealing with all things electronic and online. That's an area of expertise for Daniel Garrie, and he shares his insights. But first, a message from our sponsors, McAfee. Ideas don't come for free. Budgets are begged for, long hours are required, the months, maybe even years of research, the sheer human effort of it all, the changes, the revisions, the reworks, the results. The adaptation, the innovation, the collaboration, all lead to the final moment when it pays off. And it's perfect. Your company's work. As long as it's not compromised. From device to cloud, McAfee harnesses the power of 1 billion threat sensors to design security that moves beyond intelligence to insight. So you can move beyond optimizing security products to optimizing your security posture, and not just react to threats, but remediate threats that matter. Intelligence lets you respond to your environment. Insights empower you to change it. McAfee, the device-to-cloud cybersecurity company. To learn more, go to McAfee.com/insights. That's McAfee.com/insights. And we thank McAfee for sponsoring our show.
eDiscovery, I feel like it should just be called Discovery today because everything is nearly electronic. I shouldn't say 100%, but it's basically in litigation in the United States. So I guess for CISOs or your audience or senior cyber or privacy individuals, litigation often ensues around a breach or around all sorts of things, right? Firing employees, it depends how senior you are. There's all sorts of complicated issues that come up that involve lawyers. It's about the discovery of the responsive information relevant to that incident. Now, sometimes discovery can also involve third parties. So a lot of vendors that collect logs or have cloud-based services or whatever will get third-party subpoenas in connection with discovery involving another case. Like, for example, they may want the endpoint log files that are hosted by a third party. The part involved in a data breach, one of the lawyers may have to subpoena that company, and there'll be discovery. So it's the process of getting information as it's connected to a dispute. Now, there's also discovery in arbitration. There's also discovery in government investigations, and certainly in criminal cases as well. Those tend to be a little more draconian and arcane sometimes, or one way, or better or worse, depending on the regulator. And I was just referring to federal court litigation earlier. State court litigation with state court judges is sort of, I don't want to say the Wild West, but it varies based on the knowledge and understanding of a judge. And it's about going before a court and saying, look, we need this information to argue our case. It gets inherently more complicated because judges are generalists and they're not, the wazirs of ones and zeros, so to speak. They hear murder cases, divorce cases, criminal cases, white-collar crime, contract disputes, and everything else. When people come before them and say, we want all of the email server articulating what's reasonable to get that information back and forth is sort of discovery. Sorry for a sort of long-winded answer, but for non-lawyers, I kind of want to fill in the holes.
So when things go wrong when it comes to discovery, what are the things that you typically find yourself up against?
It ranges, but usually it can be very, from helping the parties. For example, there was a case involving Amazon and several different cloud-based service technology providers, and a case called CDS versus Rapid Systems in New York in the Southern District, where I was tasked with basically creating a set of protocols and constructs so parties could have co-equal access to a cloud-based platform as they proceeded to litigation So it was fairly complicated because it was a virtualized private cloud, and the court had no idea what the parties were fighting about or how to grant this type of thing. So I got appointed by the courts in federal court to create as a technical special master to resolve all the issues and create a set of protocols so the parties could functionally operate and update the product and release the product. But if they had different customers and different instances of the cloud, but the same source code base, and so stuff like that. And then we have like Small versus UMC, where the court, appoints me with a sort of mandate of resolving a wide range of eDiscovery issues. And as I said in the beginning, it's about finding the right information. And it ranges from parties and lawyers don't know how to properly extract or collect the information, to the vendors they hire don't do the right work, to just outright perjury and lying by parties about what they did or didn't do. I often tell people, I'm very fortunate because ones and zeros frequently don't lie. A lot of people say, oh, we didn't use our mobile devices to communicate. What people don't realize is that in every exchange environment, sent by an iPhone is on the signature line. If you use an iPhone or sent by my mobile device, it's appended to every single mail message that goes back and forth by default. And so all you have to do is search for that phrase to figure out, and their email address to figure out if they were communicating using their mobile device, right?
Now, does it happen often that people, sort of panic and start deleting things when they shouldn't?
That's human nature. It varies based on their understanding. I mean, I see the worst. I mean, I'd like to think that most people have the common sense not to destroy and delete vast amounts of information. But unfortunately, when I'm appointed in cases, there are times where they leave their employer and they delete all the files, put them on memory sticks or hard drives, and go to their new employer, and they think, oh, we're not going to have any issues. And then their new employer pretends they don't know about it or something to that effect. Or people delete a bunch of things thinking that there's going to be no trail. And, we're legal engineers and our forensics piece. I mean, inevitably we find evidence, whether it's on their device, on their mobile device, in the cloud account, sometimes in a vehicle. I mean, we've had it on medical manufacturing equipment. It's almost impossible to delete everything. And then there's always the occasional, I'm going to break this hard drive up into multiple pieces scattered around the city and think that that's okay. Or I'm going to tell them it got hit by a sprinkler when I left my laptop out at the pool and it got wet by the sprinkler system and I recycled it, and then 3 weeks later we see the device connecting to a network or something. There's inevitably issues.
Now, in these cases where you are appointed to be that neutral party, is that a process where both sides on the case agree to go by the things that you set up, the standards that you set?
Yeah, so what happens is you're appointed by the Federal Rules of Civil Procedure and Federal Court Rule 53, and the parties effectively agree to consent to my authority. And it's not even, you can disagree if you want. You can appeal my decisions, but I'm effectively an officer of the court, and I issue decisions and protocols, and I can recommend sanctions, cost shifting, whatever I think may be appropriate based on the underlying facts and the parties' behaviors. I often tell parties that, look, if you can cooperate and be transparent and honest, with the rails on, we'll keep it at, reasonably priced. If you go, and start being zealous advocates and, not being fully forthright, but generally fairly transparent, we'll keep it in the realm of reasonable. If you go off the rails, we're going to blow it out. And, I'll be forced to wind it down and chase everything down. But I often tell people or parties that I'm not one to shy away from holding parties and individuals accountable. I believe that people shouldn't litigate discovery. They should litigate the facts of their case. So when you attempt to destroy evidence, you're not litigating your case. You're effectively trying to avoid litigating your case, if that makes any sense.
Yeah, that does make a lot of sense. I'm curious, what is your advice for people who find themselves faced with this sort of discovery? Based on your experience, what are your tips for somebody at the outset of that sort of process?
If you're, at the outset of working, on a case and you just found out you're a party to the case, because it varies, right? Because if you're in a personal role, if you're a chief security officer and you're going to be deposed, or are you talking about your corporation and you know that you're about to be hit with a massive set of lawsuits, So I tell all, chief security, anybody senior leadership, right? Read your employment contract and hire a separate lawyer, because the corporation's lawyers don't represent your interests. They represent the interests of the corporation, and they may diverge. They will likely diverge at some point in the process. And so, the corporation will, of course, tell you to preserve all information and provide all the records and all the information to them and so on and so forth. And as an individual, don't delete anything, don't destroy anything. But I would hire your own personal attorney or counsel. And I would also encourage you that a lot of times downstream, you'll see litigation from when you were in your previous role. And they may send you a discovery request for anything on your mobile device because you used your work and your personal device. And you may think there's resonant facts or information in there, or you use your Gmail on occasion, whatever the situation may be. Again, in those cases, make sure that your employment contract, when you're departing, agrees to cover any and all reasonable costs that may arise, either discovery or required as a fact, if you're needed as a fact or witness in anything relating to your work. Because your new employer isn't going to be like, yeah, I'm going to give you 2 days off, and who's going to pay for all your travel or even the discovery costs, getting the information out of your systems and your machines, because it's complicated if you're doing work in your new employer. So I, encourage people to think about that at a personal level.
What about at the enterprise level?
So at the enterprise level, depending on the size of the corporation, they should have, it's very interesting. Privacy and cybersecurity end up influencing eDiscovery, because privacy is basically compelling people to have better data governance, meaning to understand where their data exists and how it operates. It's sort of like SOX. Privacy is sort of, I guess, the equivalent of what the Sarbanes-Oxley Act did for a lot of financial institutions, requiring them to have records accessible, information more accessible, more detailed reporting, and and make it so that it can be accessed and so on and so forth. Privacy is basically doing the same thing. You need to know where, not for everything, but you need to know where your consumer information is, what systems it sits on, and so on and so forth. And what you do then is you get a litigation hold or a notice, saying we're going to sue you, or you get an actual suit filed against you. And what you do is, assuming it came to your in-house or outside counsel, they'll provide legal advice telling you to preserve all of your information. If you're in IT, you probably will have an internal process and to stop, one of the things I'd recommend are don't recycle tell your employees don't recycle their mobile devices. Make sure that you've looked and made sure that your archiving and your purging processes can be activated in a reasonable fashion. Make sure that if you're using backup tapes and backup mechanisms or cloud-based, a SAN or whatever, however you're using your backup, that you properly configured so that the recovery and backup and you're not overwriting things, but make it focused and reasonable, right? Sometimes clients go way overbroad and preserve everything at huge cost. And that isn't also the intent of the law, isn't to also make businesses incur substantial additional costs. They want them to incur what we would say reasonable necessary costs. So that means if there's only one place that this information exists, then unfortunately my advice to you is preserve it and buy additional storage, buy people new phones or whatever it may be. But to balance that, if they're not a key witness and so on and so forth, you take the reasonable steps. But what you cannot do, one thing I tell corporations they must avoid doing, is having a set of policies that they struggle to follow or comply with, because then it looks like you knew what you were supposed to do, but you weren't able to effectuate it properly and or intentionally decided not to, if that makes sense. And it becomes very important in data breach litigation and cybersecurity litigation, because so many times the lawyers have no idea, Palo Alto firewall. This is an example. They're like, yeah, we have logs. What they don't realize is that every day, depending on the log window of how long they preserve them, that data is constantly flipping through, right? And, first in, first out, last, depending on whatever algorithm you have in there, right? And if you wait 2 weeks, you might lose 14 days worth of those logs, and the incident may go back 120 days, whatever it is, right? And so it becomes all about the market perception. And because a lot of lawyers don't understand the tools that are used in cyber, preservation of that information can certainly be tricky. And, frankly, a CISO's job is, he's not a lawyer. The lawyer needs to be able to effectively communicate with their clients to ensure that they're preserving that information. And they also have to be able to communicate with the third-party services that they're often using especially when it's managed CISO services, that they need to preserve that information. And all too often, that's not even considered in the contract with the managed service provider. Just as a side point, I guess worth noting is that a lot of corporations haven't invested in their information technology systems to know where their data exists. But under these new privacy laws, they are. The tricky part is if you're a public corporation but don't have any operations in certain states or customers from those states, then you don't have to invest that capital.
It's also curious to me, this I guess what I describe as a shift that I've seen where rather than being considered something of value, data is being considered radioactive, that you don't want to keep too much of it.
I often tell clients that it's not radioactive. It's does the data itself make you money or add value to your business? And I think the pendulum swinging so far to the other way. If you know you're using ephemeral messaging tools and you think that that's an okay thing to do when you're told to preserve the communications, newsflash, it's not. And more importantly, you need a corporate policy that would allow you to even use those tools for said communication. And a lot of corporations don't even have the right policies that acknowledge that this is what you're supposed to be using, right? So if you're doing contract negotiation using an ephemeral messaging tool, and then there's a contract dispute or a breach about it later, and one side took screenshots of it, you got a problem.
That's Daniel Garrie from Law and Forensics. Our thanks to McAfee for sponsoring our program. Visit McAfee.com/insights and find out why McAfee is the device-to-cloud cybersecurity company. For everyone here at the CyberWire, I'm Dave Bittner. Thanks for listening.